So what I'm going to be sharing with you is basically three things. One is a bit of our history. As you know, in the Yukon, we had contact. We went from about 15,000 people down to a population of about 4,000 very quickly. And I don't want to delve into all of the impacts. You know them all in terms of all of the viruses that came by way of contact. So we had to band together. There's about 7 tribal groups in the Yukon territory, and we all had to put our differences aside. We basically resolved and we adopted the expression "together today for our children tomorrow," just to ensure that there was unity of purpose and of mind amongst us. So up there, this reflects some of the early sort of impacts that we had. We had things like the gold rush, in which about 40,000 newcomers came in overnight within about a 3-year period of time, with all of their cultures from America and around the world. There was the construction of the Alaska Highway, and that brought in about 40,000 people as well to work on the construction of the Alaska Highway in a very short period of time. And I won't talk about the treaty process in Canada per se. I think you're all aware of historically what those treaty processes were. In terms of our own effort, because of all of the impacts, and because we live right next door to the state of Alaska, the Tlingit Haida in 1965 went to court, and they successfully sued the American government. And they won a settlement of about $7.5 million. And we were aware of their success. Now, the Americans at that point in time, or in the state of Alaska, had discovered oil, and they wanted to build a trans-Alaskan pipeline through the state of Alaska to ship out all of the oil that they discovered on the North Slope to the southern 48 states. And so they were aware of this court case, and so the American Congress, unlike now here in Canada, there cannot be an extinguishment of First Nation rights, titles, interests, clearly without your consent. But in the state of Alaska, in 1971, Congress, by an act of Congress, extinguished all of the Aboriginal title in the state of Alaska. And in return, they got $1 billion and 44 million acres of land. And that's all. They didn't get any rights to hunt, fish, trap. It was a straight land and cash deal. Now, in 1971, in the Yukon territory, from where I'm from, Canada had the authority to extinguish our interests as well. So we knew that, but we also knew historically that the last treaty in Canada was made in 1921. And so there was about a 50-year time span in which there was no treaty making in Canada. So we were aware of the Nisga'a case going to the Supreme Court of Canada, and in the 60s we agreed to work amongst the 7 tribes and the 14 First Nations in the Yukon territory to push for and try to convince Canada to negotiate a settlement in the Yukon. And in that regard, we were fairly successful. This kind of sets out sort of our 20-year timeline to initially arrive at the agreement and then conclude the agreement. We've had the effective date of our final agreements and our agreements on self-government for about 21 years now. It came into effect, ironically, on Valentine's Day, 1995. And so we've had this agreement in place. But in terms of the win by the Nisga'a, we were afraid, quite frankly, and I've shared this in the past with the Nisga'a as well, that what happens in the event that the Supreme Court of Canada had found that Aboriginal title existed but had been extinguished by adverse acts of the Crown. What happens then? Is it only applicable to the Nisga'a? And our talking point back then was yes, entirely. We could distinguish the Nisga'a precedent in terms of its application in the Yukon. So we took all of our chiefs to meet with Jean Chrétien, and we were attempting to beat the issuance from the Supreme Court of a judgment that we feared would go against our interests. But the Supreme Court of Canada said no, Aboriginal title exists. The only issue is whether or not it has been extinguished. So when we met with Pierre Trudeau on Valentine's Day, 1973, we filed a petition with him to set up a comprehensive process to negotiate a final agreement in the Yukon with the support of all of the First Nations in the Yukon. And he agreed. So in the 20-year process, in terms of what we've got, as I mentioned, 14 Yukon First Nations. 11 of them have agreed to a common structure, a format, with respect to their final agreements and their agreements on self-government as well. And there is a common piece that runs throughout every treaty that embeds what we consider to be certain acceptable concepts. And one of them is, for example, land use planning. We wanted to develop one land use structure that was applicable on all so-called Crown lands and First Nation lands in the Yukon Territory. Likewise, we wanted to develop one development assessment process that is equally applicable to all of the lands in Yukon. We also wanted to develop processes or understandings with respect to what is termed certainty in your treaties. For example, do you take all of your title, like the Nisga'a have done, and modify them to be fee simple for the 2,000 square clicks that the Nisga'a have within their treaty? In our case, we retained Aboriginal title to 16,060 square miles of land, which is the extent of our settlement land, but we said it's equivalent to fee simple. We didn't modify it in that respect because that option was not on. So that basic concept or that principle was accepted as a common theme. And I think in terms of my working experience here in BC, is that that approach, to me, makes a lot of sense. Because if there are common aspects that could be shared throughout BC, it's pretty difficult, I would surmise, that for one group, one First Nation in BC, for example, I'm assuming that this example does exist. If you constitute 400 people, it's pretty hard to put the pressure on the Crown and right of BC to accept a concept Whereas if you came to the table with 27 tribes, 40 tribes, that's a different kind of pressure that you could apply, certainly to the Crown, both in Right of BC and for Canada as well. Now, in terms of the final agreements, I just want to say that there are 28 chapters in the final agreements, and the final agreements, as you know, are treaties under Section 35.3, and that the agreements on self-government, though, because the agreements were before the entrenchment of the inherent right of self-government by Canada, our agreements on self-government are not treaty rights. They exist in the realm of the inherent right, but are not a part of the treaty, and so in that respect, it's not like the Nisga'a Treaty. It is our considered view that we could take the totality, all of the agreements, all of the contents of the agreements on SGAs and entrench them as treaty rights as well. But Canada, unfortunately, does not want to go there. So in terms of the 28 chapters, the two that I want to focus on, one is who qualifies for the treaty. Because I do know that in terms of enrollment, part of the issue or part of the question is who becomes a citizen of your First Nation in the event that you do get a treaty. We attempted to set out two tests. One was the objective test. We basically said if you are of Indian blood, we didn't specify a quantum, and if you resided in the Yukon Territory, or if you're a descendant of a person that resided in the Yukon Territory prior to 1941, the construction of the Alaska Highway, and if you can prove your ancestry linked to that individual, then you could qualify for the treaty itself. Secondly, we said there is a subjective test because there are 7 tribal groups and 14 First Nations. We basically said that every First Nation could subjectively decide their own tests as well. So that was what was accepted to us, and I know that's always a challenge to determine who would be included. And if you define your tests in a very narrow fashion and only adopt, for example, the test on ancestry, there's a lot of issues around that as well. So in terms of the reserve aspects, we did have reserves in the Yukon. We basically kept them as 91-24 lands because we felt that was important. So we didn't use the model that I spoke to in terms of retaining title. We still retain title to these reserve lands as well. And so, but the aspect of 91-24 was important to us because we wanted to ensure that there was some residual federal crown interests on the old reserves that we had as well. So we had a diversity, if you like, of title in terms of the agreements. And to the extent that there were any spec claims that survived the treaty, there was no extinguishment of any wrongful expropriations by the Crown in terms of these reserve lands. Those were retained as well. Land tenure, one of the things that we found was that, yeah, we got 16,060 square miles of land, 14 First Nations. The question becomes, how do you share that? Do you share that equally? What's the formula? Well, and in the event that you fail to work out an agreement, what happens then? You need a backstop plan. So the backstop plan that we had was that our central authority, called the Council of Yukon First Nations, with Canada, would decide what the split of land is and was. So if you've got a multi-community structure, and if the issue is you agree on a fixed amount of land quantum, be sure that you have an internal process that would agree to an appropriate division of the land. And failing agreement, you need some other mechanism to resolve the disputes that are clear to arise. I won't spend any time on access. We all know what access is. On 16,000 square miles of land, you got a lot of people that want to pass on your lands as long as they use the existing trails. There's no issues with that. Expropriation, you will all have lands that may be subject to expropriation. One of the concepts that we developed was in Chapter 8, in which we had a surface rights board. Because we were going to have split estates, i.e. there were some lands in which we only owned the surface and somebody else owned the subsurface, there's going to be disputes about land. So we used a surface boards concept to sort of rationalize and resolve those disputes that would arise internally. One of the other factors that we use were national parks, and they are reflected in a term called special management areas, because we knew on 16,000 square miles of land that was not enough for us to survive, so we wanted to protect some of our territories through national parks, territorial parks, et cetera, et cetera. So we got 3 national parks currently in the Yukon territory that are currently reflected in Chapter 10 of the agreements. As I mentioned, there's land use planning. This is the chapter that both Chapter 11 on land use planning and Chapter 12 development assessment processes we've been in court on, because there's an attempt by Canada, because it's a federal law, they want to truncate the review periods for the various projects, like a pipeline that may traverse lands in the Yukon territory. So we basically said to Canada, under Chapter 12, there's an agreement whereby Canada would consult us before they amended that law. If they failed to do that, then we certainly could challenge it. And with respect to that law, we did file a writ last year, and with the election of Mr. Trudeau now, he's promised to rescind that law, or those changes to that law that would have an impact with respect to Chapter 12. I won't go through the entirety of this, but my concluding remarks, if I were to give advice, would fall in about 3 categories. One is that when you resolve to enter into an agreement, one thing that you're going to have to look at is efficiency and how do you manage that. And in our case, initially it was our concept that we would have a central government and 14 First Nations that would have their individual power. When we took that concept out, all of the First Nations rejected that concept. They said, tell you what, if you vest all of the lawmaking power within us, we can then delegate that authority up to you. Has it happened yet? No. So we don't have any central authority with any residual power. What we got are 14 lawmaking structures that render authority. Second thing is that in terms of a division of power, generally speaking, we've managed to build in to the agreement on self-government the authority to establish our own court. So we got a First Nation court structure in which the First Nation court could adjudicate on First Nation customary law and statutory law, and by agreement on territorial laws that apply on the 16,000 square miles of land, and laws of Canada, including the criminal code, with respect to laws that may be broken on treaty lands as well. Now, Canada does not like that concept, and so, but it's built into the agreement itself. It does allow us to retain values, lawmaking, and to develop our own common laws in that context as well. So the last point is that I recognize that this is one model that works for us. It made us work as a team, recognizing all of the impacts that historically had happened to us as a people, and it's an effective model, and we've offered that and we shared that with the other First Nations in Canada, and it is in some respects complex, but it's workable certainly for us, and if there's any concepts within our agreements that we could share, we'd be happy to do that as well. So thank you very much.